This program covers the Internal Revenue Service concept of charity. The Internal Revenue Service views charity in a special sense that may not be the same as the way in which many people think of charity. The core of this presentation is an Internal Revenue Service training document which is now 30 years old, but which is still applicable today because it covers principles more than current developments. There is no comparable, more recent IRS document of which we are aware. The substance of this text follows the IRS document verbatim, except that reference to rulings and the like are omitted unless they are directly germane. The full document can be seen at the link shown on the slide, and current information about the Internal Revenue Service's latest thinking on charities can be seen at the second link shown. Although the text is primarily the IRS instructional material, the slides have been prepared to highlight elements covered in the IRS material, but the slides have no similar authority. The approach will be to read the slides to set the stage, and then to read word for word verbatim the text of the IRS instruction. The Internal Revenue Code, section 501(c)(3) contains the primary material on fully tax-exempt charities. Concepts of charity are evolving. The Internal Revenue Service, by regulation, revenue rulings, and instruction, defines what is charitable. There are a variety of theories governing charitable law. The Internal Revenue Service, section 501(c)(3), provides that an organization organized and operated for charitable purposes may qualify for exemption from federal income tax. The concept of what is charitable has varied, however, with the time, the place, and the needs of a particular community. The concept of what is charitable is still evolving today. In this topic, we will examine the historical sources of charitability, describe what has been and is charitable under the regulations, state the current service concepts of charity as derived from revenue rulings, and finally look at a variety of theories under which charity law continues to evolve. Although the origins of the concept of charity go back to antiquity, the modern American legal concept of charity is derived principally from the Elizabethan statute of charitable uses. The preamble of the statute provides that some funds should be set aside for the following charities: for relief of aged, impotent, and poor people, some for maintenance of sick and maimed soldiers and mariners, schools of learning, free schools, and scholars in universities, some for repair of bridges, ports, havens, causeways, churches, sea banks, and highways, some for education and preferment of orphans, some for marriages of poor maids, some for supportation, aid, and help of young tradesmen, handicraftsmen, and persons decayed, and others for relief or redemption of prisoners or captives, and for aid or ease of any poor inhabitants. Since the establishment of the first non-wartime federal income tax in the United States in 1894, exemption has been provided to charitable organizations. Although the 1894 Act was held unconstitutional by the Supreme Court in 1895, the language of the exemption was only slightly changed in the Corporation Excise Tax of 1909, which provided that the excise tax should not apply to any corporation or association organized and operated exclusively for religious, educational, or charitable purposes, no part of the net income of which inures to the benefit of any private shareholder or individual. Prior to the Act of 1894, the question of what to exempt did not arise except by virtue of statutory omission, since in tax acts prior to that date the acts had specified the entities to be taxed. Three basic considerations underlay tax exemption then and now. 1. Tradition. That is, the fact that historically certain types of organizations were not taxed, and the legislators were not setting a precedent by continuing the exemption. 2. Morality. That is, that Congress was generally willing to exempt the income of organizations formed for the mutual benefit of members, so long as they were primarily financed by such members. And 3. Special interest legislation. Following approval of the 16th Amendment to the U.S. Constitution in 1913, which permitted the levy of a federal income tax on persons and effectively overruled the Supreme Court decision rendered in 1895, which held that the federal income tax was unconstitutional, the Tariff Act of 1913 was passed. That act includes the same exemption provision as the Corporation Excise Tax Act of 1909, cited above, except for the addition of the word scientific and the reordering in the sequence of exempt purposes. So far as the term charitable is concerned, there has been no extensive change through a series of revenue acts from the Tariff Act of 1913 to the present Internal Revenue Code Section 501c3, although additional privileges, requirements, and categories have been added. For example, those organizations within what is now 501c3 were given the privilege, in addition to exemption, of allowance of a deduction for individual contributions by the Revenue Act of 1917. In 1934, a limitation on political activities was added, later expanded in 1954 to an outright prohibition on campaigning on behalf of any candidate for public office. In 1935, the contribution deduction was extended to corporations subject to a percentage of income limitation. In 1938, charitable contributions by individuals were limited to domestic charitable organizations. On numerous occasions, courts and other authorities have expressed the view that the term charity cannot be restricted or confined. Some particularly well-stated comments include: first, the enforcement of charitable uses cannot be limited to any narrow and stated formula. It must expand with the advancement of civilization and the increasing needs of man. New discoveries of science, new fields and opportunities for human action, the differing condition, character, and wants of communities change and enlarge the scope of charity. And again, an inflexible construction fails to recognize the changing economic, social, and technological precepts and values of contemporary society. The rationale behind the granting of exemption from tax to private entities has been and continues to be based on the theory of shared social responsibility. The government and its citizens jointly share the responsibility for the well-being of the entire nation. Early governmental authorities granted tax exemption because they were either unable or unwilling to satisfy obvious social needs. Later, exemption was extended or continued for organizations whose purposes and activities were socially desirable. Today, of course, government conducts many of the activities previously done only by private philanthropy. Even today, some needs can be better met by private philanthropy. The present system for tax exemption reflects this philosophy. This dual system of public and private philanthropy seems likely to persist well into the indefinite future. Now we get into the various purposes covered by charitable relief. Returning to the text, the concept of charity under the Internal Revenue regulations has slowly evolved and expanded. This evolution can be seen from the changes in the regulations over a number of years. Early Treasury regulations provided that corporations organized and operated exclusively for charitable purposes comprise in general organizations for the relief of the poor. The fact that a corporation established for the relief of indigent persons may receive voluntary contributions from the persons intended to be relieved will not necessarily deprive it of exemption. These regulations remained in force and unchanged through the years until 1956, when the service issued proposed regulations stating, quote, organizations formed and operated exclusively for charitable purpose include generally organizations for the relief of poverty, distress, or other conditions of similar public concern. The fact that a charitable organization established for the relief of indigent persons may receive voluntary contributions from persons intended to be relieved, or that a hospital may require payments for services from those able to pay, will not necessarily preclude exemption. End quote. The regulations proposed in 1956 were withdrawn. Following an extensive study by the service, the following regulations were introduced in 1959. Quote, the term charitable is used in Section 501c3 in its generally accepted legal sense and is therefore not to be construed as limited by the separate enumeration in Section 501c3 of other tax-exempt purposes which may fall within the broad outlines of charity as developed by judicial decisions. Such term includes relief of the poor and distressed or of the underprivileged, advancement of religion, advancement of education or science, erection or maintenance of public buildings, monuments, or works, lessening of the burdens of government, and promotion of social welfare by organization designed to accomplish any of the above purposes, or to lessen neighborhood tensions, to eliminate prejudice and discrimination, to defend human and civil rights secured by law, or to combat community deterioration and juvenile delinquency. These major delineations of charity set forth in the regulations remain in effect today. This regulation section is quite plastic, however. In each category there have been expansions beyond the original meaning of the term at the time the regulations were enacted. As will be seen in the next section, each of the areas has expanded or changed as a result of court decisions, new types of organizations, and newly recognized charitable needs and classes. It is not clear whether this approach will continue to be used by the service, given the paucity of instances in which the rationale has been applied. However, its use is likely where there is agreement that the activity is charitable, but disagreement as to whether the activity can fit into any of the more explicit definitions of the term charitable. The relief of the poor, or those in similar distress, is one of the four oldest recognized charitable purposes. The service cites the phrases relief of the poor and relief of the poor in distress, or relief of the underprivileged, in a number of revenue rulings. In an early series of cases, the service took the position that a charitable bequest must be limited to charity, that is, to the poor as a class. These cases arose either as direct questions of exemption from federal income tax or of the deductibility of charitable contributions by individuals or estates. In a case involving the Young Men's Christian Association, the service argued that an organization failed to qualify for exemption if it limited the beneficiaries of charity to a particular group or class. The court concluded, "We do not think that the mere restriction of the beneficiaries of an otherwise charitable organization to a designated group or class is sufficient upon which to deny exempt classification." In another case, the gift out of an estate's property to a hospital to build a wing in the memory of the deceased's mother was disallowed by the service because it was not limited to charity. Similarly, in a further case, the testator had willed her residuary estate to an exempt hospital to create a special fund, quote, to provide special nurses and special nursing care for nurses who are graduates of a recognized school of nursing and are patients of said hospital. The executor of the estate deducted the charitable remainder interest under the predecessor of Internal Revenue Code 2055A, but the service disallowed the entire deduction and insisted a deficiency existed. At least two revenue rulings have adopted this approach. So this area of consideration remains somewhat unclear. The service has not singled out any particular class or group of persons as automatically being poor in distress or as being underprivileged. It is found, however, since the publication of the current regulations, certain activities conducted for or on behalf of or to benefit identifiable classes of people to qualify as charitable activity. These classes and the related activities include homes for the aged, including continuing care retirement communities, employment placement of the elderly, senior citizen centers, a rural rest home, meals for the homebound, closed circuit radio broadcasting, low-cost transportation in unserved areas, and specially constructed housing for the elderly. The needy artists, musicians, composers, writers, and scholars, otherwise financially unable to complete their projects, and women needing to market their cooking and needlework, and the handicapped, meals for the homebound, and low-cost transportation in unserved areas, including specially constructed housing for the handicapped. In addition, low-income individuals qualify for charitable consideration. Families' housing needs and financial counseling and related budget services have been viewed as charitable. Homeowners' interest-free repair loans in badly deteriorated areas. Individuals receiving financial counseling and related budget services. Residents receiving free legal services in economically depressed communities. Unemployed and underemployed non-skilled persons needing educational and vocational training. And organizations of public housing tenant groups. Moreover, free legal services and free blood when hospitalized for the indigent have been allowed as charitable. Persons accused of crime, if unable to raise bail or pay bondsman's fee. And the foreign poor, rural inhabitants of development countries and the underprivileged in Latin America. A common characteristic running through these 7 classes is the element of poverty, which seems to reflect the service's traditional approach. However, the service has expanded this position to include exempt organizations that benefit a particular class which is not generally considered to be poor. For example, the service recognized as exempt an organization that awards scholarships to students strictly on the basis of scholastic ability without regard to financial need. The service found that a trust for educational purposes is charitable, although the persons to be educated are not limited to the poor. This ruling effectively expanded an earlier revenue ruling, which ruled that an organization that provided worthy and needy students with housing and with financial assistance, gifts, grants, scholarships, no-interest loans, etc., to enable them to attend a college or university may qualify for exemption. Subsequently, the service ruled that an organization could benefit employed factory workers by providing a work-related child care and development center for their preschool-aged children. In this instance, children were selected on the basis of financial need of the family. In addition, the organization took in children recommended by the local anti-poverty and welfare agencies. The term distressed generally is not equated with poor. The former term is used in revenue rulings dealing with emergency situations and with the elderly. A volunteer fire company whose primary activity is firefighting and rescue work may qualify for exemption as its services relieve the distress. Such an organization must itself be directly engaged in charitable activities and not be operated in a manner similar to organizations operated for a profit. Such was the rationale for denying exemption to an organization that rents housing and reforms related services at a cost to a city for use as a free temporary housing shelter for families whose homes have been burned. With respect to the elderly as a distressed class, two earlier revenue rulings found that an organization that operated a home for the aged could qualify for exemption if it met certain additional requirements. In Revenue Ruling 72-124, the service set forth several requirements as alternatives to those found in the two earlier rulings. For a home for the aged to qualify as an exempt organization. In this ruling, the service stated that providing for the special needs of the elderly has long been recognized as a charitable purpose when the elements of relief of distress and community benefit have been found to be present. This ruling does not classify the aged as a charitable class as such, but it does recognize that the elderly, apart from financial distress, have special needs including housing, health care, and financial security because of their advanced years. This recognition of the special needs and circumstances of the elderly may be due to the awareness of the conditions of life of older people in American society, quote, augmented by the increasing number and proportion of the aged in the population and their consequent greater visibility to the rest of society, end quote. No revenue ruling cites relief of the underprivileged by itself when describing whether or not a particular organization qualifies for exemption. Rather, the phrase relief of the poor in distress or relief of the underprivileged is used entirely, or merely the phrase relief of the poor and distressed. In only one ruling has the service nearly described a particular class or group as definitely underprivileged. In that ruling, an organization had been formed in the United States to work directly with village groups, jungle colonies, and other groups in a Latin American country to assist underprivileged people in improving their living conditions through educational and self-help programs. The organization's activities included furnishing tools, educational materials, and other supplies. It was primarily educational in nature. The service concluded that furnishing tools and material to help improve living conditions of the underprivileged is charitable within the meaning of Internal Revenue Code 501c3. While the service early recognized relief of the poor as a charitable purpose, at no time has it identified one or more classes of groups as automatically poor, distressed, or underprivileged, so that any activity conducted for such class by a nonprofit organization will enable the organization to secure exemption from federal income tax. Rather, the service has expanded that concept to include activities that benefit persons of low income, that's a monetary approach, and the elderly, which is a sociological approach, on the basis of circumstances or special needs of the particular class. The service does not use relief of the underprivileged as a separate reason for finding any organization exempt under the Code. Internal Revenue Code Section 501c3 includes words in addition to the word charitable. If the word charitable had been used alone, then the popular meaning of the word would have limited its applicability to only organizations which relieve the poor. However, Congress appears to have wanted to extend the concept of charitable to include other purposes and activities, as many states do, and not limit the term merely to relief of the poor. The terms educational and scientific are separately defined in their own regulation sections. The regulation sections provide fairly good definitions of what is meant by the terms. The term advancement is not defined. Arguably, advancement of education or advancement of science goes beyond being merely educational or scientific. Advancement in terms of charity can be construed as a more liberal charitable standard where admittedly educational or scientific activities are present. Advancement of religion is also a very liberal standard in terms of charity. What is religion is, of course, a problem upon which the regulations and revenue rulings give almost no guidance. In addition to this liberal standard, the service and the courts have been reluctant to examine religion too deeply because of First Amendment considerations. This suggests that organizations desirous of qualifying as religious or advancing religion can qualify for exemption if the religion in question fits within the common understanding of the term. The phrase erection or maintenance of public buildings, monuments, or parks first appeared in the regulations in 1959, and since that time has been used sparingly in revenue rulings. The service has always used the phrase in conjunction with the phrase lessening of the burdens of government. For example, the service ruled that an exempt organization that created and maintained a public park would not have its exempt status jeopardized if it accepted donated land from the corporation that formed and controlled it and used a picture of the park as its brand symbol. The service stated, quote, "Establishing and maintaining a public park is an activity similar to erection or maintenance of public buildings, monuments, or works, lessening the burdens of government and the promotion of social welfare for any of these purposes." End quote. Later, the service supported this community-wide benefit theory in the case of an organization formed to preserve and improve a lake used as a public recreational facility. The maintenance and improvement of public recreational facilities appears to be generally accepted as a charitable purpose if the other requirements in the regulations are met. For example, the service ruled that an organization that provides funds to a city transit authority to ensure that bus service for the city is continued by the proprietary bus company until the city can take over its operation may qualify for exemption because it is assisting the municipal government in conferring a benefit upon the entire community. There is no published definition of public building, monument, or work. It is reasonable to apply the doctrine of noscitur a sociis, that is, to qualify as a charitable organization performing this purpose, the subject of the organization's activity must possess the general characteristics of a public building. In one case, a court found that an organization that met the requirements of our Internal Revenue Code sections 501 to 504, and which had a reasonable objective in accumulating substantial funds to construct a civic building for a county, qualified for exemption. That this phrase has always been cited in conjunction with the phrase lessening of the burdens of government indicates at the minimum that the service has been reluctant to use the phrase as an independent means for justifying exemption, or that these two phrases are in effect inseparable of government structures or of public works such as lakes or waterways. This latter concept may be due to the fact that each phrase, different words, public and government, are used to indicate benefits for the community at large. Because of the absence of this phrase in court cases generally, and as an independent basis for exemption in revenue rulings, it is unlikely that the erection or maintenance of public buildings, monuments, or works will ever become an independent basis for exemption for a large number of organizations. The phrase lessening the burdens of government was not included in the regulations until 1959. It's only since that time that the service has cited that phrase in revenue rulings. The service has taken several approaches in applying this phrase to organizations seeking exemption. In the first approach, the service cites the burdens phrase and either makes no further reference to it or simply concludes that the activity involved lessens the burdens of government. The second approach focuses on whether there are direct or implied cost of work savings to the government that are attributable to the activities of the organization. In 1962, the service ruled that an exempt organization that distributes its income to a state or municipality or to an activity that is an integral part thereof does not jeopardize its exempt status, provided that the funds are used to carry out the purposes which constitute the basis of the donor organization's exemption. References are to city beautification, rehabilitation program for released prisoners, student internships in government, etc. The third approach is assistance in the performance of governmental functions. The service ruled in 1974 that an organization that assists the police department in the apprehension and conviction of criminals by making funds available for rewards qualifies for exemption because, quote, the gratuitous performance of services to federal, state, or local governments is charitable in the generally accepted legal sense, end quote, and such activity lessens the burdens of government. Consistent with the governmental functions approach is the concept that if benefits derived flow principally to the general public, or if the organization's purposes are beneficial to the community as a whole, the activity will be considered charitable. For example, the service has ruled that an organization formed to preserve and improve a lake used extensively as a public recreational facility qualifies for exemption. The rationale for this conclusion is that such action ensures the continued use of the lake for public recreational purposes and constitutes a charitable activity, and the benefits derived from the organization's activities flow principally to the general public through the maintenance and improvement of public recreational facilities. The service has also noted that traffic control and safety are universally recognized as a governmental responsibility, and that an organization which provides expert opinions to local government officials regarding the existence of hazardous traffic conditions in their communities is lessening the burdens of government. In the approaches based on cost or workforce savings in government functions, The service has taken the position that the activity itself must be charitable before the service will recognize the activity as also lessening the burdens of government. The fourth and most current approach, the governmental designation approach, is to determine whether the activity conducted is a governmental activity or function. Initially, the service considered what independent legal authorities have determined to be governmental functions, and this was used extensively. Because of the wide range of activities undertaken by various governments, a tax exemption because an organization lessens the burdens of government may grow to accumulate the widest variety of exempt purposes that are charitable, but do not fit easily into any of the other charitable purposes. The service expressed the view that the government is the party best qualified to decide whether a particular activity is sufficiently in the public interest to warrant its recognition as a legitimate function of government. Prior to 1959, promotion of social welfare was not defined as charitable. The 59 regulations officially recognized for the first time that promotion of charitable welfare may constitute a charitable activity. The reason why this phrase was included in the regulations is difficult to ascertain. It may have resulted from the general recognition that the term charitable is not to be limited to the purposes enumerated in the code, but may be influenced by judicial decisions, as we saw in our discussion concerning relief of the poor. Or there may be other reasons. The types of activities which have been found to be charitable as the promotion of social welfare have been many and varied. First, it may be used without reference to any of the purposes enumerated above: relief of the poor and distressed, or relief of the underprivileged, advancement of religion, advancement of education or science, erection or maintenance of public buildings, monuments or works, or lessening burdens of government. Or it can be applied to the subparts which are listed here: the lessening of neighborhood tensions, the eliminating of prejudice and discrimination, the defense of human and civil rights secured by law, the combating of community deterioration and juvenile delinquency, the advancing of equal job opportunities, the planning for a metropolitan area, the providing a recycling center, or support for immigrants. From this, we can conclude that the recent IRS rulings have expanded the concept of charity, and that further expansion is likely. Promotion of health has long been considered a charitable purpose, as evidenced by the reference in the Elizabethan Statute of Charitable Uses to, quote, maintenance of sick and maimed soldiers and mariners. Originally, the service based exemption of health care providers on the standard of relief of the poor. The service's standards for exemption for organizations promoting health underwent a series of changes between 1956 and 1969. This change was the result of several factors. First, the service had conducted a study concerning the definition of charitable. The results were published in the 1959 regulations, which supported the definition of charitable in the generally accepted legal sense, and listed a number of types of activities that benefit the community. This expanded the prior regulations, which had had a limited definition of charitable. Secondly, Congress passed Medicare and Medicaid to provide federal payment of medical bills incurred by the elderly and the poor. Third, it was generally recognized that third-party reimbursement for medical expenses was steadily covering more and more people. And Congress added a new section that an organization shall be treated as organized and operated exclusively for charitable purposes if 1. It performs one or more enumerated services that it could perform on its own behalf if it was a hospital, or 2. It performs such service, for example, for 2 or more exempt hospitals. The publication of a 1969 revenue ruling sparked a number of healthcare-related rulings in which the service found the promotion of health to be a charitable purpose within the legal sense of the term charitable. The following kinds of organizations were found to qualify for exemption: a drug rescue and counseling service, a group residence for former mental institution patients, homes for the aged, home health care for the elderly, construction to attract a physician to an unserved community, computerized organ donor matching system, a halfway house for alcoholics, therapy and services for children with learning disabilities, health systems agencies pursuant to statute, a Christian Science medical care facility, hospice for the terminally ill, and a private hospital room when it was medically beneficial. Recently, a trust created by an exempt hospital for the sole purpose of accumulating and holding funds to be used to satisfy malpractice claims against the hospital, and from which the hospital directs the bank trustee to make payments to claimants, was also ruled to be exempt. Exemption was granted because the trust is operating as an integral part of the hospital and is performing a function that the hospital could do directly. Promotion of health will continue to be an independent basis for exemption for health care and health-related organizations. Further, promotion of health will be expanded to cover wholly new areas. The healthcare field is ever expanding as larger and larger segments of our society seek more comprehensive health care. Not articulated in revenue rulings or procedures, but present in each public interest law firm application for exemption, is the issue of competing public interests. For instance, even if litigation seeking an injunction against a business for pollution of the air or waterways in violation of some law is successful, it is not absolutely clear that the overall effect of the litigation will be beneficial to the community. In one case, the appeal went to the U.S. Court of Appeals for an award of attorney's fees, and the court split 4-3 and granted the fees. But the dissenting opinion states, quote, "We respectfully dissent. It is difficult to see that either of these plaintiffs acted as a private attorney general, vindicating a policy that Congress considered of the highest priority." While the provision of legal services will continue to be an area of increased activity given the activist and adversary nature of contemporary society, the limits of exemption for public interest law firms seems well delineated. Other legal services provide structures such as prepaid legal services plans, which seem unlikely to be included within the scope of exemption in the future unless a new theory of charitable exemption evolves. In such cases, entities similar to prepaid legal services plan may have to be given their own exemption subsection with an independent rationale for exemption rather than included under the concept of charity. From this, we can conclude that exemption issues are more finely defined as we move from what are clearly charitable activities in the generally accepted legal sense. We've discovered that promotion of public health can be exempt, environmental action can be exempt, and some public interest legal services can be exempt. In determining whether an organization qualifies for exemption, the service has applied the common law principle that to be treated as a charitable entity, an organization may not operate illegally or contrary to public policy. Present-day public policy concerning racial discrimination in education is rooted in the 1954 Supreme Court case. As a result of these expressions of public policy, the service has taken the position that private educational institutions that are exempt may not discriminate on the basis of race, color, national or ethnic origin, and retain exempt status. The public policy rationale has also been used to reach decisions on organizations engaged in picketing, demonstration, and economic boycotts. Other rulings provided that an organization formed to lessen racial and religious prejudice in the fields of housing by conducting investigations and research qualified for exemption. An opposite result was reached where an organization formed to promote world peace and disarmament by non-violent but illegal civil disobedience did not qualify as exempt. Finally, a job training program limiting admissions to American Indians was held to qualify for exemption because the limitation required by federal law governing funding of training programs for Indians was not racial discrimination, was not contrary to public policy, and was not inconsistent with charitable exemption. The public policy rationale will probably continue to be used, as in the past, not as a positive basis for exemption, but as a requirement which, when not met, will result in denial of exemption. The Code provides that organizations exempt under its provisions may not carry on propaganda or otherwise attempt to influence legislation. Such organizations are prohibited from participating or intervening in any political campaign on behalf of any candidate for public office. However, there's been ambiguity in how to apply this principle to activities which fall within the realm of interest of an organization and on which the organization might have a clear opinion that could conceivably influence legislation. The Tax Reform Act of 1976 sought to clarify the ambiguities inherent in this requirement not to be a, quote, action, end quote, organization by enacting an elective provision. The impetus for this may have been the report of a commission which was critical of the limitation on legislative activities. 5 categories are excluded from the term of influencing legislation. These 5 are making available the results of nonpartisan analysis, study, or research, providing technical advice or assistance in response to a written request by a governmental body, appearance before or communications to any legislative body if a proposal might materially affect the exempt organization, communications between the organization and its bona fide members unless the communications directly encourage the members, directly or indirectly, to influence legislation, and routine communications with government officials and employees. However, the prohibition on supporting a candidate for public office is generally presumed to be absolute. Amateur athletic organizations were not considered to be charitable organizations. They did not fit under any definition of charity, nor were they considered charity in its generally accepted legal sense, because there was no historical precedent for finding such organizations to be charitable. To remedy this problem, Congress enacted sections into the tax code that provided that exemption would be recognized for organizations organized and exclusively to foster national or international sports competition, but only if no part of its activities involved the provision of athletic facilities or equipment. This last condition, that no part be used for athletic facilities and equipment, created difficulties, and therefore most of these organizations could not qualify as educational. This was clearly not the intent, it was just the result. The legislative history indicates that the provision was meant to work to preclude exemption only to social clubs and other organizations of casual athletes. The legislative history was clear that the new provision was not intended to adversely affect the qualification for charitable tax-exempt status or tax-deductible contributions of any organization qualifying under the standards of existing law, and the tax law was revised in 1982 after the publication which forms the text for this presentation to modify the prohibition on the provision of facilities and equipment. So reference to later authorities is essential for this topic. From this we can conclude that exemption questions become more problematic for organizations that do not have as clear a charitable purpose as did the traditional concept of charity as relief for the poor and distressed. There has been considerable tax legislation since this paper was prepared, so later authorities need to be considered. A variety of theories have been used to justify recognition of exemption where there is doubt that the formal requirements for recognition have been met. In one ruling, the service ruled that an organization exempt under the code that distributed part of its funds to organizations not themselves exempt, but ensured use of the funds for otherwise exempt purposes by limiting distributions to specific projects that are in furtherance of its own exempt purposes would not jeopardize its own exemption. This is called the conduit theory. The organization must retain control and discretion that the funds are used for recognized purposes. The adjunct or integral part theory applies when an organization conducts activities not charitable in themselves. These activities would be permissible to an exempt organization if the organization conducting the activities is controlled by one or more such exempt organizations. The adjunct theory was first enunciated by the Seventh Circuit U.S. Court of Appeals in 1934. The first application was in 1951, where the Ninth Circuit U.S. Court of Appeals reviewed the tax status of a corporation organized to operate a bookstore and restaurant on the campus of the State College of Washington. The court concluded that the organization was an educational organization exempt under the code. In reaching this conclusion, the court cited the effective control of the organization by the state university. Because the organization bore a close and intimate relationship to the functioning of the college itself, the organization was an adjunct of the college and exempt. The third evolving concept is the essential purpose theory. With the enactment of Internal Revenue Code 7428, the declaratory judgment provision, the essential purpose theory has found increasing use and favor with the courts. This theory favors formalized requirements of Internal Revenue Code 501c3 and concentrates instead on the essential purpose of the organization, minimizing the importance of the business aspects of the organization's activities. The intent of the current regulations was to liberalize the IRS position with respect to classification as charitable organizations of those social welfare organizations designed to accomplish one or more of the four enumerated social welfare purposes. Thus, for social welfare type organizations, if the essential objective, the essential purpose of an organization, is to promote social welfare by achieving any of these purposes, then the organization qualifies regardless of the fact that some or all of the individuals who benefit from the organization's activities are not members of a traditional class of charitable recipients. So from this, we can conclude that there are a number of common elements which lead to exemption, but there are practical considerations that enter into it and simply make the determination of whether any particular activity or organization is exempt more complex. And this is further complicated by the impacts of judicial decisions through the courts. The concept of what constitutes a charity is fluid and evolves as concepts of the public interest evolve. Charity can be in the eye of the beholder. So the IRS has to balance disparate conceptions and disparate interests in carrying out its mission. Anyone with doubts about whether a particular activity or organization is charitable should seek expert advice from a qualified advisor who is versed on the current laws and current thinking of the IRS and other authorities. Common among all these theories is the fact that they permit exemption for organizations which cannot be clearly categorized as a particular type of charitable organization within the traditional types delineated in the regulations. Thus undifferentiated, the organizations rely upon these theories or others closely akin to them to justify exemption. As the number and variety of exempt organizations increase, the number of organizations which are unable to fit into the recognized categories will also increase. The fact that the Internal Revenue Service has in the past denied exemption to these organizations does not necessitate a similar result today. The declaratory judgment provision for Internal Revenue Code Section 501c3 organizations will result in a large number of these undifferentiated organizations obtaining exemption through the courts. That's the end. It's clear that the question of what constitutes charitable activity and what qualifies an organization for tax exemption is very unclear and requires expert advice and expert representation, and even then the outcome may be uncertain. Thank you for participating.